In the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we're here for sentencing in People v. Caitlin Enick. It's filed 25-7110FH. Counsel, you want to state your appearances, please?
Anthony Julie on behalf of People.
No, and I have Ms. Enick, Gauthier is in person in custody to my right.
All right. Good morning. We're here for sentencing on the High Court misdemeanor of lying to a peace officer with the advisory guidelines scored at 0 to 11 months. Mr. Nightingale, any additions, corrections, or modifications to that report?
Not to the guidelines themselves. I would just note that on CFJ 145, page 1, it does state that her district court case has a 2-year max. When I go back and I look at that judgment of sentence, that judgment was not marked consecutive. So I would interpret that as a 1-year max, but would leave that to the court's discretion on whether to update that or not.
Oh, well, it's a probation max. So I read that as just the length of her probation term. Is she on a 2-year term of probation?
That is correct, yes.
All right, any additions, corrections, or scoring challenges from the people?
Just one correction, same page, currently under sentence. She's actually not under sentence right now in district court. She will be sentenced this Thursday.
Oh,
Friday, I believe.
Friday, excuse me.
oh, so she's, wait, what's the October 10th sentence? It says she's on probation.
I believe that's when she was sentenced to probation in district court, was on 10/10/25.
So then she's under sentence, under
Okay,
probationary
correct.
sentence. Is she being sentenced for a probation violation this Friday? Oh,
That is correct.
so she is under a probationary sentence, so that still is correct. Okay. Do council know what the anticipated sentence in the district court is? Is it a continuation or a discharge of probation?
I would anticipate a discharge.
Okay, thank you. Mr. Nightingale, anything you want to say on your client's behalf?
Yes, Your Honor, thank you. So Ms. Enick comes before the court today, 19 years of age. She has 2 prior felonies that we've just referenced out of district court, but those are, attempt to commit felonies. She did plead to misdemeanors down there. Understanding, obviously, that's going to be used against her in the future, but nonetheless, that is, I think, the extent of her adult criminal history is what's downstairs. She does have some juvenile record that I'm not gonna comment on too much, but she's a very young person, right? She comes before the court, as I said, at 19 years of age. She does have decent family support. Her mother's here today. Kathleen's in the back here to support Caitlin. As we've said just previously, I do think that she's going to be discharged from that probation down in district court. She was sentenced to essentially a sobriety court term of probation for 2 years. She was on probation for, I believe, about 2 weeks. And then this incident happened. She was sort of getting on the on-ramp, right? And then was sort of immediately derailed. And I think in her process of getting on that on-ramp, she had at least lined up some employment. She hadn't started that employment yet, but had lined it up. It's my understanding that she could go start work, tomorrow if she were to be released, but I'm not sure if the court's going to do that or not based on the recommendation for 6 months. She also was to get a substance use assessment set up, participate in those counseling services. I think everyone in the room acknowledges, 2 weeks is probably not enough time to have that stuff actually set up, let alone to be able to get that report back and then begin those services, which is just unfortunate. I think that Ms. Enick, as it's outlined in the PSI and in Ms. Martin's conversations with Ms. Landcore, is that Ms. Enick is easily impressionable. She's a person that when she gets around the wrong folks, she does the wrong things. And when she's around the right folks, she does the right ones. And so I hope that this process for her has been a really big wake-up call about who she does and does not associate with in the real world. She's got a long life to live, ideally. And, these choices are going to could come back and haunt her, right? If she doesn't continue to make the right ones, or if she continues to make the wrong ones, either way. She does need to finish her schooling, it sounds like, and I think she's aware of that. You know, Judge, in my communications with Miss Ennick, she's a person who is very blunt. I mean, that's just sort of matter of fact. You know, I think the court may or may not get some sort of negative perception from her about the way that she carries herself. I think that some of that is youthful ignorance, maybe, about, you know, how others perceive her as she travels through the world. I think some of this is also a response to trauma, and I think some of that trauma is outlined in the PSI for her. That goes back when she was 3 years old. I think the court's aware of who her biological father is, and the kind of life that she was subjected to until she was thankfully, you know, rescued by her grandmother and now her mother. And so I'm certainly thankful that Miss Lancourt stepped up and was able to take care of Miss Ennick and her siblings. You know, it sounds like she just has still a positive relationship with a lot of her family members. Obviously, I continue to encourage her to seek that good family support and to shy away from these folks who are going to cause her to make poor decisions. As outlined in the PSI, you know, Miss Ennick does give a statement that I think pretty much encapsulates this whole case, right? She's hanging out with the wrong people. She gets busted, and then she lies to try to save them, and in doing so, you know, really shoots herself in the foot, not just with this case, but with her sobriety court probation sentence. And so all that considered, I mean, the recommendation is pretty fair and measured. Her guidelines are 0 to 11 as outlined in the report. She does have credit for 116 days. This is the longest, to my knowledge, that she's been incarcerated. I think she served 50 days, 50 days on the probation sentence in district court before she was released to probation. And so what I think, maybe if the court would consider giving her a 4-month window of initial incarceration, allowing her to start this probation period. I do not know what her sentence is going to be in district court. You know, she's subject to a year. And so, you know, if Judge Eichdahl's very mad at her, which he may be, that may be what she's doing. I'm not sure at this point. But as far as this case is concerned, we would like to get her probation started sooner rather than later. And that's what we're asking for today. Thank you, Judge.
Thank you, Mr. Nightingale. Ms. Ennick, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me or no?
Yeah.
Go ahead and stand up.
That night, I was trying to be nice. I was trying to help people, Pat. I had no idea that they were going to steal a car. I had known before. I should have known when they were talking. And I was like, I was trying to do the right thing and be a good friend to somebody who was not a good friend in return and got me in trouble. I should not have run, and I should not have fled that night. I did that because I was scared of what was going to happen. I went home and I turned myself in. I told my mom what happened, and I turned myself in. I lied to try to deflect the blame from myself, and that was wrong. I admit my wrongs, and I'm sorry for my actions.
All right. Thank you, Ms. Ennick. You can have a seat. Mr. Juliet, any recommendations from the people?
Your Honor, I would ask for a sentence at near the top end of the guidelines. I was the prosecutor in probate court when she was a juvenile, and she was under juvenile probation there for the longest time. Not long after that, she got the 2 attempted felonies at district court for which she was on probation, intensive probation. I mean, we had to basically draft our own probation sobriety court terms for her, and that only lasted 2 weeks until the instant offense. I recognize this is not the most serious high court misdemeanor. It's a 2-year max, but probation just doesn't seem to be working. And I recognize that she's only 19 years old, but it's just not working. If the court's not inclined to give a near the top end of the guideline sentence, I would ask for, at a minimum, a longer term of probation, because otherwise I suspect, and I'm just guessing here, she'll pick up another felony and be a habitual fourth at the age of 19 or 20 years old. Thank you.
All right, thank you, Ms. Enick. If you please stand for the court sentence. Ms. Enick, this is your first time in front of me on a criminal matter. I know you've been in front of me on something else, but you're only 19 years old. And it sounds like, you know, you've been in enough trouble in the juvenile court and in the district court that, you know, the prosecutor's office is to the point where they're kind of throwing up their hands. And we've been trying with Ms. Enick and she's not cooperated here. And that's completely understandable from their perspective, right? I mean, they've given you chances and you've just continued to commit crimes. Circuit court's, you know, a different deal. You know, when you're on felony probation, then, you know, there's a lot of time that can be over your head, even though this is a 2-year statutory maximum. You know, if you commit more crimes on felony probation, you'll end up doing a significant amount of time. It's concerning to see at only 19 years of age. In the pre-sentence report, the compass assessment, you know, there's just a lot of services that are recommended. And your risk scores are medium and high. Sounds like you were only on probation with the district court for a very short period before this offense. And the sentencing offense is for lying to the police about the situation where you and some of your co-defendants were stealing a car, fleeing from the police. I know you're not the driver, you know, but you're with them, you're involved, you're lying about it. That's dangerous, troubling stuff. And, you know, that's going to quickly get you in a lot of trouble. I don't know what the district court's going to do. Maybe you'll do a year in the district court. I don't know. But I think I'm more concerned about what services we can try to provide for you on felony probation than exactly how many days you do on this charge on the upfront part. So what I'm going to do is I'm going to place you on probation, but it's going to be for not the 1 year as recommended, but I'm going to place you on probation for 2 years, for 24 months, subject to the terms and conditions listed on pages 2 and 3. I want to highlight a couple of those. You have to complete substance abuse treatment when referred. You're going to have to complete your education. You're going to have to get and keep a job. I am going to strike paragraph 12, the no contact provision with the co-defendants. I think that makes a lot of sense on as a bond condition under these circumstances. As a probation condition, I think that would be difficult to enforce. And the benefit for trying to enforce it would not outweigh that. There's a crime victims assessment of $130, court costs of $350. You have to comply with DNA testing and pay a $60 fee, $68 in state costs. There is a monthly supervision fee to the Department of Corrections. And I think for all the information listed in the pre-sentence report, I'm more interested in probation than incarceration in this case. I'm going to order that you serve 116 days jail and give you credit for 116 days previously served. So that means on my order, you'll be able to be released and begin your probation. But that's up to the district judge of how soon that's going to be. So then, you know, your attorney can present that on Thursday or Friday to that court. But within 24 hours of your release, I want you contacting your supervising agent, Agent Martin, so you can get going on probation. I imagine there's a hold in the district court, so she's going to be in custody till Friday then?
Yeah, there's no bond.
Okay. All right. You're eligible for early discharge from probation up to halfway point if you've succeeded on probation. We're going to hand you a piece of paper explaining that. Also, if you wanted to appeal, you can do so by filing an application to the Court of Appeals. If you wanted a lawyer, you'd have to ask within 6 months. So we're going to hand you a piece of paper about those appeal rights and ask you to initial one copy for us. The other one's to fill out if you want to take an appeal. Do you have any questions for me, Caitlin?
No.
Okay, good luck to you.
Thank you, Judge.
So off the record.